Thank you for joining us, everybody. This is our monthly pro bono webinar. This one is on gathering evidence and presenting claims before the Executive Office for Immigration Review and USCIS. Apologize for the typo on that main screen there. It should be USCIS. My name is Ashley Hebner. I'm a managing attorney at the National Immigrant Justice Center. I'm here with my colleague Lisa Koop, who's an associate director of legal services here. And we're going to talk today about sort of what is the end part of your representation of a client, which is, putting together that case before the immigration court or the asylum office. And this is going to be geared primarily towards asylum claims, but a lot of what we're going to be talking about is also applicable to presenting other types of claims for relief before the immigration court. So very briefly about the National Immigrant Justice Center, NIJC is a legal services organization located primarily in Chicago with offices in Indiana and DC that provides immigration legal services for low-income immigrants, primarily in Indiana, Wisconsin, and Illinois. We're part of Heartland Alliance. We serve more than 10,000 immigrants each year, but a vast majority of our clients are served through pro bono attorneys, and I know many of you are listening on the webcast today. We rely heavily on our pro bono attorneys and hope that these webinars are very useful to you as you move forward with your case preparation. All right, so moving right into the webinar. We're going to talk first about gathering evidence in asylum and immigration court cases. Again, whether you're before the asylum office or the immigration court, the way you gather evidence, the evidence you're going to use to support your asylum case is generally going to be the same no matter which agency you are in front of. So as a brief refresher on the evidence in asylum cases and immigration cases overall, in an asylum case, the burden of proof is on the applicant to establish that the applicant is a refugee. So that means the burden of proof is on the applicant and the applicant's attorney to prove that he or she meets the 5 tests for establishing asylum eligibility. So the well-founded fear of persecution on account of one of those 5 protected grounds, by the government or an entity the government is unable or unwilling to control. And it's important to remember those 5 elements. We're not going to talk about them separately today. We have other presentations and trainings on those issues. But when we're talking about evidence and corroboration, you need to provide evidence on each of those elements. You need to provide evidence of persecution. You need to provide evidence of who the persecutor was. You need to provide evidence of why the persecution occurred. So it's critical to remember that evidence is involved in each of those elements of an asylum claim. Now, the statute says that the testimony of an applicant can be enough to establish your asylum eligibility. So the testimony alone can be sufficient if it's credible and sufficiently detailed. However, the statute also goes on to say that an adjudicator can require any corroborating evidence. And then if the adjudicator requires that corroborating evidence, the applicant is required to provide it or show why the applicant cannot reasonably obtain the evidence. And what's really important to keep in mind there is the adjudicator is generally not required to give any notice of the need for corroborating evidence. So if you go to your immigration court merits hearing and the judge determines that there's a piece of corroborating evidence you should have, generally the judge is not required to then continue the case to another date to allow you time to find that evidence. So that means when you go to your merits hearing, you need to have corroborated every single part of the case, every single part of your client's history, or explain through your client's affidavit or other documentation why certain evidence is not reasonably obtainable. So as you begin your representation of an asylum client, it's always important to keep that in mind and from the beginning start thinking about, can I corroborate this? Can I corroborate this? Can I corroborate this? So what evidence is important? And the short answer is everything is important. In an asylum case, because the judge can demand corroboration of everything, and because the burden of proof is on the applicant, and because credibility is so critical in an asylum case, you need to corroborate and provide evidence on every single aspect of the case. But generally speaking, this gets broken down into 4 different types of corroboration. The first is country condition evidence. Country condition evidence is critical for a number of different reasons. First, it shows that what your client is testifying to is credible and plausible. So if your client is saying that he was imprisoned after a political opposition march in his country, you want to provide corroboration to show that that march actually occurred and people were arrested at that march and people were imprisoned as a result of those arrests. So you need to show that what happened to your client is consistent with what is known as happening in that particular country. Country condition evidence is also critical to show other parts of the asylum test. So for example, showing that the government is unable or unwilling to control your client's persecutor. So for example, if your client is a woman from El Salvador who is fleeing an abusive partner, you're going to need to rely on that country condition evidence to show that in El Salvador, the police don't intervene in domestic violence situations. And if you call the police, they might ignore you, or they might arrest the perpetrator for such a short period of time that it actually places your client in greater danger. And maybe there's only 3 domestic violence shelters in the whole country. And there's high-ranking government officials that talk about how domestic violence is a family matter, things like that. So you need to look at the country condition evidence to prove that element. And then sometimes, depending on your claim, if you have a particular social group claim, you may need to use country condition evidence to show that your client's particular social group is a group, so that the characteristics of the group are something that is shared by other people. Or if you are in a jurisdiction that requires you to utilize the social distinction and particularity tests for social group membership, which is not in the 7th Circuit, but in other circuits, you may need to use country condition evidence to prove that people in your client's country perceive of people with this characteristic as forming some kind of group or as being recognized as socially distinct within the country. So country condition evidence are really critical for all aspects of the claim, and you want to be creative when you're looking at that country condition evidence. The State Department human rights reports and sort of well-recognized human rights resources like Amnesty International and Human Rights Watch are good places to start, but they definitely should not be the end of your search. For a lot of your clients' cases, you're really going to need to dig into domestic and foreign news sources. A lot of our clients have experienced things that are not going to be reported in U.S. sources, so you need to look at foreign media, at local media, to talk about those things. For example, we often represent clients from Francophone countries in Africa, where the situations in the country is not reported on by U.S. media, but is reported on heavily by French media. And so you'll need to go to those sources to try to corroborate what happened. So under the next column, client-specific evidence, this can be more obvious in many cases, but it's important not to forget all the different ways you can corroborate your client's specific circumstances. So you want to corroborate, very simple things like when your client entered the country, because you need to do that in order to prove that your client filed for asylum within 1 year of the entry, but you also need to actually corroborate who your client is. So we have had cases in the past where we've seen immigration judges say, if everything that you say happened to you is true, you may be eligible for asylum, but I haven't seen you provide enough evidence that you are who you say you are. So something very simple as providing proof of identity can be really critical. And that, of course, doesn't need to be through a passport. That could be through affidavits of other people who know you, who know your client, school records, things like that. But you need to find a way to corroborate who your client is and any other pertinent relationships to your client and to the case. Physical evidence such as, police reports, pictures of a ransacked home, things like that are also incredibly useful, but they may not be available in the vast majority of cases. But again, that's one of those things that if you don't have that evidence, you want to explain why you don't have it. So for example, if your client was threatened by a gang member and reported it to the police, and your client cannot get that police report, you need to explain why that police report is not reasonably obtainable. So maybe it's too dangerous for your client's family member to go to the police and request the report, because then the gang members will know they're doing that. Or maybe your client's only family members in the country live in several towns away and it's too expensive for them to go to the police to request that report. So again, just make sure you explain why you don't have that evidence. Witness affidavits are really critical, and we're going to talk a little bit more about the format of these affidavits later on. But be really creative when thinking about who can corroborate what my client experienced. If your client says a family member knew about something, you want to try to get a statement from that family member. Getting statements from people who may not have firsthand knowledge of what your client experienced, but had something similar happen to them. We even use affidavits from people here in the United States who don't have firsthand knowledge, but when the client came here, they confided in that person, and that person can then have an affidavit to provide secondhand information about what happened to the client. And then finally, looking at maps. We often find maps are a really effective way for both the client to remember the experience and be in a better position to narrate his or her story, but also to help the adjudicator understand the exact situation that the client experienced. So showing where the client's home was in relation to school where the persecution occurred, or showing where the client attended church in relation to where a political protest occurred if they were all in the same area. That can be really useful to have a general sense of why your client couldn't escape by going elsewhere, or why your client was always harmed on this particular day because she was always in this particular area. So definitely don't discount the usefulness of maps to really set the picture for the adjudicator. When you're establishing past persecution, what's really critical is mental and medical evaluations that can provide really scientific evidence of what happened to the client. So if you have a client who experienced past persecution and has some physical evidence of that past persecution, maybe scars, maybe some hearing loss from being hit in the head, or vision loss from having some damage to an eye, or some sort of ongoing pain, it can be really, really critical to have a forensic medical evaluation done for that purpose. There are several different ways you can go about getting a forensic medical evaluation. It can be difficult sometimes depending on where your client lives. Physicians for Human Rights is one entity that can help with that, although I believe they are not currently accepting intakes at present. If your client resides in the Chicago area and has been a victim of state-sponsored persecution, the client could potentially be receiving services from the Marjorie Kovler Center, which is a sister program of NIJC's at Heartland Alliance, and you can reach out to NIJC for a referral for that purpose. But that can be a really useful way to corroborate past persecution. Mental health evaluations can provide the same sort of corroboration. So a mental health provider who can say that the client is experiencing symptoms consistent with the trauma that he or she says they suffered. And a mental health evaluation can also help corroborate certain aspects of a client's testimony that may not seem consistent with what the client experienced. So if the client, has trouble looking in somebody's eye when talking about past torture, or the client has memory issues or issues presenting the story in a chronological fashion because of the past torture, the mental health evaluation can be very useful for that purpose as well. And then finally, for future persecution claims, here affidavits can be really critical from similarly situated individuals, especially if you have a claim that's based purely on future fear where there's been no past persecution. You need to prove something that's going to happen in the future that has not happened yet, and that can be really challenging. So looking to other similarly situated individuals who have also been persecuted to say, this person was in the political party just like I was, and they were arrested 3 times and were tortured. If I go back, the same thing's going to happen to me. That can be really powerful evidence. Or, for example, for a young man who's fleeing gang recruitment in Honduras, he was able to escape. Well, there were only threats before the threats got too severe. And you could get affidavits from other individuals who can say, my cousin was recruited by the gangs and he said no 3 times and then they killed him. Or my brother was recruited by the gangs and they beat him up severely and then he had to flee to the United States as well. So those affidavits can be really helpful. Expert affidavits, particularly for court cases, can sometimes be quite useful too. This depends a lot on the country of origin. There are many countries now where you can find so much great detailed country condition documentation from news sources and other entities that you don't necessarily need a country condition expert, but in some cases you do, or in some cases where there's a really specific issue that country condition documentation generally won't touch on, an expert affidavit can be really useful. And then again, getting evidence of past harm that may not rise to the level of persecution, but can be indicative of what happens in the future. So again, if your client was repeatedly threatened by a gang member, getting corroboration that those threats occurred can help establish what may happen to your client in the future. All right, so what evidence is admissible? And the short answer here is everything. So the federal rules of evidence do not apply in immigration court or before U.S. Citizenship and Immigration Services. However, adjudicators may give more weight to evidence that does generally follow the rules. So, you don't necessarily need to prove chain of custody and fully authenticate all your evidence, but if you do, the judge is likely to give it more weight. Similarly, you are not required to submit things in formal affidavit format, but if you do, it's generally going to be better received and given more weight by the immigration judge. But to keep in mind that the Seventh Circuit has clearly held that the federal rules of evidence do not apply in immigration court. The only test for the admission of evidence is whether the evidence is probative and its admission is fundamentally fair. So everything's going to get in, generally speaking. The question is how much weight the adjudicator is going to give the evidence. And because everything is going to get in, this is why it's so critical to be very creative when thinking about what evidence you can gather to submit in the case to support the claim that might not fly in another court setting, but will be admitted in immigration court. So just generally speaking, in obtaining evidence, you want to always start early because getting that evidence is going to take time, especially if it's coming from abroad. And I think gathering that evidence is something that attorneys can easily forget about because you get very focused on the legal argument, what are the arguments you want to make in the case, focusing on the brief. But really, a significant time needs to be spent on the affidavit and gathering that corroborating evidence. So you always want to keep those three pieces in mind as you're beginning case preparation. While you're working on the client's affidavit, you want to be thinking about the legal arguments, but you want to be thinking about the corroborating evidence in support of those arguments and the statements in the affidavit as well. Begin with those very basic things, corroborating that your client is who he says he is, that he, did experience this harm, but then keep going beyond that to corroborate each of those asylum elements in the test. We're going to talk, more about being really creative and using social media, because everything gets admitted in immigration court, generally speaking, and particularly at the asylum office level, you can use things like Facebook posts to provide corroborating evidence in your case. So it's not uncommon, for example, for our clients to have been threatened by a persecutor via Facebook or via text. And so you can submit screenshots of those threats as proof of the harm to your client, or as proof of the past persecution, or as proof of the well-founded fear of future persecution. You can communicate with potential witnesses via Facebook or WhatsApp in order to prepare affidavits to provide corroborating evidence. And even sometimes if you're not able to prepare a formal affidavit because of the limited communication with the witnesses, you could even, again, submit screenshots of those text messages or those WhatsApp messages or Facebook posts in order to support the case, particularly when trying to get signatures for affidavits and those types of documents. We've had a number of cases where the witness in the home country, we were able to communicate with them back and forth and talk to them in order to prepare an affidavit, but for safety reasons or financial reasons, the family was not in a position to print out the statement and sign it and send it back to us. That was not something they were going to be able to do. But what they were able to do was write out that they, are signing under penalty of perjury on a piece of paper in their home and sign that statement and take a picture of it and then text us that picture, which we were then able to print out and use as the signature page with the affidavit that we prepared in working with them. So you can be really creative in gathering this evidence with your clients and with your client's family. And then establishing chain of custody. Again, this isn't necessarily required, but it's going to help you provide more weight for the evidence that you're submitting. And it's also important because you want to make sure you know where your client got that evidence. If your client can't explain where the evidence came from, then that might raise some red flags that your client is not sure how the evidence obtained, and it might not have been obtained in a way that's going to be useful in court. It's not uncommon for clients to feel very pressured to gather certain type of documentation because their attorney tells them it's very important to have this. And so they may then call home to a family member and say, hey, can you get me a copy of this birth certificate? Can you get me a copy of this police record? And the other family member will get it in some way that's not entirely above board, totally unbeknownst to your client, and then send that to the client. And so the document may not necessarily be authentic. Your client may not know that, but you will need to find that out by asking your client how they got the document and how it was obtained so that you know that there's no issue with a particular document. All right. Making your client a partner in gathering evidence is really important. And again, I think something that attorneys sometimes forget because they sort of divvy up the roles and think, this is something I need to do as the attorney. I need to figure out what the evidence is, and I'll do the research and gather the evidence on my own. But this is really a team effort. And this is something you need to work closely with your client on. If you simply give your client a list of things to gather, that's going to be very intimidating for your client. They may be very worried about what's going to happen if they can't get the evidence on the list. They may not understand what you want them to get, and that is very easily where you also may end up with evidence that's not necessarily, was not necessarily obtained in the most legitimate way, or it doesn't really do what you want it to do. If you tell your client, please go to your mother and have her write a letter about why you need asylum, you're not likely going to get an effective statement back. So really work with your client and determine with your client what evidence can be obtained, what's the best way to obtain the evidence, and go from there. You also want to make sure your client understands the importance of the evidence. A lot of times clients may be nervous about trying to obtain certain things because they don't want to put a burden on their family member in the home country. They might feel guilty about having left the family member in the home country, or maybe they're worried about, you know, whether or not it's going to be safe to get. And if it's not safe to obtain, of course, we don't want to put any family members in danger. But if your client doesn't truly understand the importance of gathering that evidence, they may not necessarily realize that they need to push to get that evidence. So really work with your client, make sure they understand what is the legal theory in the case, what does this evidence help prove, why am I, as the attorney, asking you, clients, to get this information or help me get this information for me. And again, just really be careful about placing people at risk. And this is where we really do rely heavily on clients. If a client tells you it is not going to be safe for my sister to go get this police record, then that's fine. And you explain that in the affidavit. The client's affidavit can explain why it's not safe, and that should be sufficient to argue that it's not reasonably obtainable. So we definitely don't want to place people at risk. We do sometimes work with organizations in the home country that are able to operate and get certain documents that our clients cannot either do on their own or cannot do safely. So if there is a piece of evidence that you think is really critical in the home country, but your client is not able to obtain it, and you're representing an NIJC client, please don't hesitate to reach out to us, and we can talk to you about some potential referrals to organizations who may be able to assist in gathering that evidence. So what format is acceptable? Again, because the federal rules of evidence don't apply, there's no specific format, but we strongly, strongly recommend that in terms of witness statements that they almost always be in a formal declaration or affidavit format. Once in a while, you will have to submit something that's, a handwritten letter that's, in very summary format and doesn't provide all the details. But generally speaking, you want to be able to speak to the witness, to prepare a declaration or affidavit based on your conversation with that witness, and then to work with them to find some way to get a signature page for that particular declaration or affidavit. Because otherwise, we see again and again that if you, send a letter with bullet points to the witness and say, please write me a letter and address all of these bullet points, you're going to end up with a statement that says something to the effect of, the client is a good person, he's really afraid to come back, please grant him asylum. Because the witnesses aren't going to know what's critical for the case, what needs to be, included in the statement. They may or may not be terribly educated or very literate. So it's generally best, and we strongly recommend that the attorney actually prepare these statements in conversation with the witness. Keep in mind that there is next to no technology in the immigration court, and so you can't, ask to show videos in court, generally speaking, to play audio. If there's a web link to a particular video, you can include that in your index, and then the judge or the asylum officer can look at it at their leisure, but you can't depend that they will do so, and that actual video or audio won't be in the record. So what you need to do in most cases is print out screenshots of the video or, transcribe audio or video so that the paper visual version of that audio or video is actually in the record itself. And then finally, keep in mind that all foreign documents must be translated into English and include a separate individual certificate of translation per each translated document. The certificate of translation doesn't need to be by a certified interpreter. It just needs to be by somebody who can swear that they're proficient in English and the other language and translated the document to the best of their ability. You can find a sample certificate of translation in NIJC's Asylum Manual on our website. You can find a sample in the Immigration Court Practice Manual as well. So once you have all this evidence, how do you present it? We strongly recommend that you present all your evidence in an index that is annotated. And so there's an example here on this slide of how that will work. So, everything needs to be tabbed alphabetically and consecutively paginated. But when you get to the point of all of your country condition documents, you really need to annotate them with the most critical parts of those documents in the index themselves. Because in many asylum cases, you will be submitting, 100 or 200 pages of supporting documentation, and most likely the judge or the asylum officer are not going to read through all those documents. But if you have the most critical components in the index, then the judge will read the index most of the time, and they'll get the clear picture of the country conditions for the case. We've seen many times where during an oral decision by the immigration judge, they will literally say pieces from the annotated index when they are explaining why they're granting asylum. They will cite to those corroborating pieces of evidence, the country condition documents, and they will read verbatim from what was in the index itself. So we strongly recommend that you do submit the annotated index. It's very helpful to both the asylum office and the immigration court. And one last thing to keep in mind, we can't emphasize enough how important it is to build your record in these cases, particularly when you're at the immigration court level. We mentioned this in our last webinar, which was focused specifically on Central American and Mexican asylum cases. But depending on the jurisdiction where you practice, there may be a significant likelihood that if the judge grants your client asylum, the case is going to go up on appeal. And bad records are what creates bad law. So you need to have the strongest record possible so that if the worst case scenario happens and the judge grants asylum, but the government appeals, or the judge denies asylum and you appeal, you have a strong record to take up to the Board of Immigration Appeals with the possibility of going even further to the Court of Appeals. And now I'm going to turn things over to Lisa, who's going to talk about how you present all this evidence once you are at the asylum office or the immigration court.
All right, hi everybody. My name is Lisa Coop. I'm an attorney at NIJC and do a lot of work with Ashley on our asylum project and in other sorts of removal defense matters. So let's go ahead, and Ashley's driving things from Chicago. I'm actually in northern Indiana, so I'm going to have to give her verbal cues to forward the slides. But let's go ahead and do that now and talk about how you actually present your evidence before the asylum office and the immigration court, recognizing that there are some pretty significant strategic differences in how you're going to present your case, whether you're at the AO or before the immigration judge in that adversarial setting where you've got a government prosecutor on the other side. So at the asylum office, you're filing your documentation, that annotated index, which is so very critical because both the asylum officers and immigration judges are under incredible pressure to process cases quickly. And you want to make it quick and easy for them to digest your evidence and reach the conclusions that you're trying to lead them to about the nature of your evidence and the legal arguments that you're putting forth. So that annotated index, I always tell the law students that I teach and attorneys that I work with that it's very possible that the adjudicator is not going to read your full packet, but if you can get them to read that annotated index and have those those nuggets of information included there, that's really significant. So at the asylum office, you're not going to have the opportunity in most cases to put on other witnesses. It's going to be your client. If your client is a child, a very young child who's not capable of really testifying, then you might bring in a parent or bring in an adult. But in most instances, it's not useful to bring along other witnesses. The asylum officer usually won't want to hear from other witnesses. They'll want to hear from your client. So you're resting on that written documentation very heavily. And so if you've got other people who are fact witnesses or who might be expert witnesses, you need written affidavits from them to submit at the asylum office. And at the asylum office, you don't get to do the type of oral advocacy that you do in the immigration court. You don't get to lead your client through a direct and draw out facts and information and frame things the way that you feel is the most strategic way to present your case. You are sitting behind your client and mostly quiet, barring exceptional circumstances, until the very end when the asylum office will let you give a closing statement. So, and that closing statement is usually pretty brief. Oftentimes the asylum office or the asylum officer is sort of done at that point, might be packing up their file and kind of half listening to what you're saying. So again, having your arguments really set forth clearly in written form is so very critical at the asylum office. In immigration court, you have much more opportunity to engage in oral advocacy, but it's no less important to have a strong written record. You know, because hopefully the immigration judge walks into court having read your materials, and you've won half the battle. You've got her familiarized with your case facts and with your legal arguments and with the parameters of your case. So, you know, there is no shortcut when it comes to preparing the written documentation, when it comes to preparing a good brief. So make sure that that you spare no effort to obtain the evidence that you need. Those letters of support, those affidavits from family members, those, you know, screen grabs of Facebook or WhatsApp, all of those things can be very critical. And I think it's a little bit unsettling for attorneys that are used to practicing in other settings where you're, you know, very concerned, and rightfully so, about things like hearsay and, you know, chain of custody and authenticity and all of that stuff. And it's useful to the extent you can abide by those rules. They're useful, but you know, you can bring in all sorts of other evidence, because there is recognition by the immigration system that it's not realistic for us to be able to present witnesses from the home country, and so we do rely on these other means in order to bring the evidence in. Now, like I said, in court, there is significant opportunity for attorney argument. And here, it's critically important. You know, we try to provide a lot of very useful sample indices and country condition documents that are already compiled, and sample briefs that you can work from. But you have to be very conversant in your own evidence, so that when you're engaging in oral argument against the government attorney, you're prepared and you know your documents. So, for example, I was in court not too long ago, and you know, the government attorney said, well, the respondent's own documents suggest that internal relocation is possible. Here's this UNHCR document talking about this like safe sector of the country where the client could go and live and be safe. And of course, internal relocation is one of the things that the government will usually try to raise as a reason why your client shouldn't win asylum. And because I had reread that document myself before coming to court, I said, well, you're cherry picking my evidence. And the next paragraph of that report talks about how women who are fleeing domestic violence aren't safe in that place. And I think, you know, you're misrepresenting the UNHCR's document. So, you know, you have to know your own documents so that you can push back, and also so that you can draw the court's attention. You know, when the government attorney says, well, you know, I think the client didn't try to go to the police, or the client, you know, made zero effort to report what was going on, for you to be able to say, Your Honor, if you can look at tab E, page 76 of my filing, there's documentation of retaliation against witnesses who report crimes, or there's documentation of the levels of corruption and infiltration of law enforcement by gang members or by cartel members. And so that's the reason why it wasn't reasonable for my client to go there. And so be ready to engage with your documents and show the court precisely where they need to look. There's not a lot of value in submitting 300 pages of paper if the court never has an opportunity to really understand what's on there, and you are the person, you're the, you know, the mechanism through which that information needs to be conveyed. So do take very seriously this whole process of collecting and submitting documents. So let's turn now to the next slide and talk about the legal memo or the brief. So when you're before the asylum office, rather than submitting a full brief, you'll do a legal memo, which is more like a cover letter or a more truncated explanation of your legal argument. You still need to make your legal argument. You still walk the asylum officer through the asylum elements, but you want to get there quickly, recognizing that they're going to have pretty minimal time to review, and that most asylum officers are lawyers, but not all of them are. So your writing style for your legal memo maybe will be a little more accessible than it might be when you're writing, when you're, you know, relying a little bit more heavily on legalese before the immigration court. But tell the story in your legal memo. Use it to introduce the asylum officer to your client, to the case. You know, this is not, you don't need to spend a lot of time talking about how section, you know, INA section 208 sets forth the requirements for asylum. The requirements are blah, 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 blah. Like they know that stuff. What we need to tell them is, what is our client's story? What are the salient facts? and how do these fit into the definition of a refugee? How does this make my client an asylum, or an asylee? So talk through why your particular social group is viable, and establish nexus. Asylum officers get hung up on nexus a lot, so make sure in your cover letters you're addressing the nexus points and connecting the harm that your client experienced or fears with the particular social group that you've established. So make sure that your challenge in your asylum office brief or asylum office memo is to put together a very concise but persuasive summary of the asylum claim. Now, when you get to immigration court, you want to do a more formal legal brief. And this type of briefing goes straight back to law school legal writing classes. And I think in a lot of our practices, or a lot of the practices that our pro bono attorneys work in, they do different sorts of legal writing. And this is just pretty much back to basics, pure legal writing, where you're setting forth facts, you're stating the law, you're applying the law to the facts of your case. And it's a forum to do persuasive writing and to really push the court and lead the court to your conclusion. So here we want to stay around 25 to 30 pages, which gets really difficult, especially if you've got 2 or 3 or 4 particular social groups and maybe a political opinion. And that's a point where you can call up Ashley, or you can call up me if you're working on an NIJC case, and we can talk through, is this getting too unwieldy? Are we proposing too many PSGs? But generally trying to stay in that ballpark is worthwhile, while at the same time recognizing that you need to preserve all of your arguments. But if we go to the next slide, I can show you an outline or a table of contents of one way of doing this. And again, starting your legal writing, starting your brief with an outline that then becomes your table of contents, I think is a really good way to do this, so you don't just start writing and find yourself kind of getting lost in the elements, and it can start to feel really redundant. And so taking the time to set out a clear outline of your case, I think, is a really, really good practice that we strongly recommend. So, at the top there, we have the statement of the facts, and in the facts we include both the facts of our case. And again, we're doing persuasive writing here. So in your affidavit, you're writing in your client's voice, you're including, not everything that ever happened to your client, but some facts that maybe are less directly relevant to the claim, a little bit more background on your client's education and family system and so forth. When you're writing your facts section in your brief, you're going to be much more strategic to make sure that you're getting directly to the point, and really casting your client's case in the strongest light. And then you want to include information about country conditions. So, here are my client's particular particular circumstances, and then here's the state of the law, or the state of the country as to gender violence in Honduras. And then here's how gang violence plays out in Honduras. And a lot of our asylum cases these days are a mix of these domestic violence claims and gang violence claims. And so you have overlap between those two areas, but really do a little bit of a deep dive and pull in some recent, update the country condition documentation, pull in some recent documentation and include it in your country condition section in your brief, so that, again, you're putting it front and center in front of the judge and making your record. So when we get to the legal argument part, I think it's really nice to include a summary of the argument, which you could put up top near that introduction or preliminary matters. A lot of us do that when we're doing our federal court briefing. It's not as common in immigration court, but I actually think it's really useful, and it essentially can be what you would use for your opening statement, to just have like 1 page or about that length of a summary of the case that sets it all out there and begins to frame the conversation from the outset. But when you get to the argument part, walk the court through the elements. So here, Jane Smith experienced past persecution. Well, what was the persecution? Let's break it down. There was the domestic violence, and then there was the cartel violence. And so let's explain exactly what that persecution was, and then move on to talking about her particular social groups. And again, if you have a religious-based claim or a political opinion or a race or nationality, you would make those arguments here. But let's establish that our client has a protected characteristic, in this case 2 particular social groups. So let's establish that the particular social group is cognizable. So that's our first hurdle. Is it really a PSG? Can this be recognized by the court? And then second, is our client a member of that group? Because we see cases that fail not because the particular social group isn't cognizable, but because the court finds, okay, you've got a particular social group that works, but you haven't established that your client is in it. And particularly if we're talking about women in relationships that are unable to leave, okay, we've got ARCG from the Board of Immigration Appeals. That's a pretty recognized particular social group, but then we need to establish that our client actually is unable to leave her relationship. So if your client was able to physically separate and move to a different location, or if she never tried to leave, what are the things that tell us that she actually was unable to leave? And so pay attention to that piece of the argument, both establishing the PSG and your client's membership in there. And then you move on to the nexus component. Okay, so she's in this particular social group and her persecution was on account of that membership. So here's where we move into the section where we connect the particular social group to the persecution, and you move through that and clearly set that out in your nexus section. And I think it makes sense to break it down. So she was persecuted on account of her PSG of Honduran women in relationships they're unable to leave. Next subsection, and she was persecuted on account of her membership in the group of Hondurans who report cartel crimes. And then from there, we move on and acknowledge that we've now got this presumption of future persecution. So we've established past persecution on account of a protected ground. So then break it down, and you can keep this pretty simple. She's presumed to have a well-founded fear of future persecution. We know that the government can't rebut the presumption with internal relocation or changed country conditions for the reasons that we've set forth up in that fact section where we talked about gender violence and gang violence or cartel violence in Honduras. And then once we've established that well-founded fear of future persecution, we move into the government unwillingness or unable to control, which is another asylum element there. And it starts to feel a little redundant because you've talked about country conditions in a couple of places already, so you don't need to restate what you've already argued. Maybe you pull another useful quote from your documents into that section, but you also can just reference up, like, as recognized above, the internal relocation is impossible because there's no police protection. Well, that argument then plays here in this section on government unwillingness or inability to control. So walk the court through the elements, not only because you want to make sure that the judge understands your arguments, but you also want to make sure that you're preserving your record for appeal. And you want to set forth your elements very clearly in your brief, because when judges start to conflate the elements, when they start muddling, persecution is only persecution if it's on account of something, or nexus, a PSG is only valid if it's incorporated with the nexus component, then we start to see really messy decisions from the judges. It can lead to bad results. It can lead to complicated appeals. And so taking the time to really set things out clearly in a brief, I think, makes a lot of sense. And then, at the bottom, we talk about our client's eligibility for relief under the Convention Against Torture and relief for withholding of removal. And those are things that if your client doesn't have other kickers in her case, if she doesn't have criminal convictions, if she's not outside the 1-year filing deadline, this might be a very, very short section that you put in there to preserve eligibility for those forms of relief, but you may or may not need to expand that much. And then take the time to write a useful conclusion, to write a brief. I usually try to do more than just say, for the foregoing reasons, my client should be granted asylum. I try to, summarize again in just a few sentences. Here's the reason why legally we win asylum, and why, as an exercise of judicial discretion, we should win. So this is one way to set out a brief. We have sample briefs on our webpage that might have slightly different ways to arrange your legal argument. But do take the time to set forth your argument in a coherent way. And I think that'll make the writing go a lot faster. And quite frankly, it makes it a lot more fun to write it. Like, you really get to dig in and develop some of these creative and fun legal arguments and engage with your record. And to me, it's a little bit, the prize at the end of, gathering all of this evidence and working with your client and grinding out all these affidavits. The treat is that you get to sit down and write out the legal argument, which as lawyers, I think many of us really enjoy doing. And frankly, we know that most of you are really terrific writers and good at this. So, give yourself the time and the space to give your brief the attention that it needs. So let's move on to the next slide, which is just a few more thoughts on brief writing. One is just write persuasively. I think, again, some attorneys come from different legal fields where you're trying not to be maybe as direct as we want people to be, or we suggest that people be in the in your legal brief. So write persuasively and make sure that you're preserving all of your arguments. I think this is stuff that we've largely covered already. Ashley, jump in if there is more you wanted to add on this point, but I think it's just a suggestion that you keep in mind that this is advocacy writing. We're not writing a dispassionate review of a case, but we're really trying to compel the court and lead them to the conclusion that our client should be granted protection. Now, when you get to the facts section, I think it's really tempting to just cut and paste from the affidavit, and I sometimes see my law students do this, and they sometimes even forget to change the pronouns, but that's not what the facts section is for. The facts section is for you to distill out the most useful and persuasive facts from your client's case. So really trim it down and include what's useful. Obviously, you have to include anything that you're going to reference down in the argument section needs to be up in that fact section. But use that to use your voice. So here you're, you get to use maybe more sophisticated language to tell the story, and make sure that that you're not just recycling the language that you pulled together for the affidavit, which the affidavit serves a different purpose. The affidavit is your client's voice, your client's telling of the story, and this is where you get to do it, where you get to use terminology that's maybe a little bit more sophisticated to tell the story in a very persuasive manner. So let's go on to the next slide. Use signposting in your brief. Make sure that you're telling the court where you want to go, and again, be persuasive in your signposting. Every sentence that you're writing should be, moving the argument forward. And also avoid recreating the wheel. So we have a lot of sample briefs that are available on our webpage for our volunteers who are registered for NIJC's webpage, and you can pull those sample briefs, but also make it better. There's always room for improvement. So, use that as a starting point, make your own outline, and then, the law is forever changing. And so update the law and update the arguments. Don't assume that what we've got there in our samples is necessarily the best way to do things. It's a good place to start, but make sure that you're improving upon the existing model, and then go ahead and send it back to us when you're done, and we'll add it to our brief bank for future pro bono attorneys. And then go ahead and look in our asylum manual and to our practice advisory. So if you're doing a particular social group case, check out our practice advisory on a particular social group, because we've got a ton of case citations and summaries and reviews there that are a really good starting off point for you when you're writing your brief. So use the resources that we've tried to pull together to the extent that they're useful to you. And hopefully that will make your legal research a little bit easier and less onerous as you're working up your case. So when you get to court and you've got your brief, you've got all of your materials, and we can go on to the next slide. When you get to immigration court, this is, your materials have already been filed 15 days before court, usually, unless your judge gave you a different filing deadline. I had a judge give me a deadline a month before my hearing recently, so that's not entirely out of the ordinary. So always make sure and confirm your filing deadline to make sure that you're getting your documents in on time. And again, if you've inherited a case from another pro bono attorney, go back and check to make sure you know what that filing deadline is, that you filed your documents with the court directly. So you've either walked it over to the court and handed it in, or you've mailed it in, and then you've served the government attorney. So they've got their new e-service system. So you've either uploaded your documents to their system, or just as easily when you're walking over to immigration court, you can drop off a copy for them. There's a special box where you can serve the government there, but make sure you're serving the court and you're serving your adversary, the Department of Homeland Security. And when you get to court, the judge and the trial attorney will both have your documents there. And at the very outset of the hearing, the judge should review your documents and give them exhibit numbers, and then she'll ask the government attorney if they have any objection to any of your documents. And they may or may not have objections. If they do object, we'll talk on the next slide about that, but you want to make sure that the judge formally admits your evidence so that it's in the record. So if God forbid you find yourself on appeal, you've got that documentation that's already been admitted to the record. Now, once it's been admitted, when you get your client on the stand, and this will feel a little bit uncomfortable to attorneys who are used to authenticating every piece of evidence with their clients on the stand, you don't have to do that in immigration court. So unless the evidence has been challenged in some way, once it's admitted, it's admitted. You don't have to do anything further to it. And given the short amount of time you have to present an asylum claim, it's not necessarily a good use of time to go through exhibit by exhibit and say, Ms. Miller, do you recognize, this document that's at tab C? Can you tell me who wrote it? Can you tell me where it came from? Really, unless the government is contesting the evidence or the judge is expressing concern about its origins, you don't need to spend time like that. Now, strategically, you may want to highlight certain pieces of evidence and maybe even have your client read from a document or two in some instances, but by and large, you don't need to do that, and it's probably not the best use of your time. Now, on the next slide, if you do run into a government attorney who's objecting to your evidence, don't simply roll over. This is an adversarial proceeding, so come ready to fight. And be ready to fight for your cause. They're going to say, well, this document is hearsay, Your Honor, and so we can't let it in. And you can say, the test here is whether it's fundamentally fair for this evidence to be admitted. It's not whether or not it passes all the federal rules of evidence. And Your Honor, to the extent that you have concerns about the origins, those might go to the weight of the evidence, but certainly not to its admissibility. And you don't even have to concede that the origins should be suspect. So be ready to duke it out a little bit and fight for your documents. I had a trial attorney try to suggest that my expert affidavit shouldn't be admitted because it was very long, and he thought it was too long and he thought it was too general. And so I, went through the experts, and he thought that maybe the expert didn't have the quite the necessary requirements to be an expert. And so we looked at the expert's CV, we talked about the fine work he'd done in the past, and we walked through the substance of the expert affidavit and really kind of had a discourse about whether or not that expert affidavit should be admitted as an expert affidavit. So be ready to push on that. And these might be some instances, like I said, where you want to authenticate. An expert affidavit you wouldn't, but if you have a government attorney saying like, well, this police report looks shady to me, like I don't think it should be admitted. If you are comfortable with where that police report came from, and you can have your client talk about it on the stand, then do that. And that's another reason why, when you're in the midst of trial preparation with your clients, make sure they know what's in there and they're familiar with all of the documents that are in their file. So I'll always actually, at my first trial prep session is usually just a few days after we've just submitted all of our documents. And so I'll bring out the hard copy of our full filing and I'll walk the client through every exhibit. Now, we don't go through and read every country condition report, but my clients will know, what kind of country reports are in there, what is their purpose, why are we using them, what are we trying to show the court, so that at the beginning of the hearing, when the judge says to your client, Ms. So-and-so, are you familiar with the contents of your application? Are you familiar with your evidence? They say yes. And, in a hearing I had a week and a half ago, the trial attorney on cross-exam asked my client, well, you're telling us that your abuser continued to look for you after you left Honduras. How do you know that? And she said, well, my uncles told me this. My uncles told me that he came looking for me. And the trial attorney said, well, do you have letters from your uncles? Because I want to see, if that evidence exists, I certainly want to see it. And she said, I don't have letters from them because it was unsafe for them, because they live in a town that's controlled by the cartels, and the cartels are connected to my abuser. And if they had tried to send me letters, the cartel would have known and they would have been punished. And that satisfied the immigration judge. Now, what you don't want to have happen in that instance is have your client say, I don't have those letters because my attorneys never told me I needed them. So this is why from the outset you want to be telling your client, like, okay, you're referencing this person in your story. Can this person get us an affidavit? Why or why not? So that your client, again, is a partner with you in identifying and collecting evidence. So when situations like that arise in court, you have a good explanation for why evidence isn't there, and you can show the court that you've really looked under every stone and explored every possible option to get any sort of evidence that could reasonably be expected to have been submitted on behalf of your client. So On the flip side, so let's go to the next slide. If the government is submitting evidence, and they don't often do this, most times they don't file briefs before court, maybe they'll come with a country condition document, but in the vast majority of cases I've been involved with, the government hasn't produced any evidence of their own. But in the event that they do, take a close look at it. You know, just because maybe the government didn't object to any of your documents doesn't necessarily mean that we're going to return the favor and not object to any of theirs. Now, they oftentimes will bring documentation on the day of, and you could argue that it's untimely in some instances. They might argue that it's impeachment evidence, and so they're not bound by those time restraints, and that may be correct, but you can still scrutinize those government documents. So if they, for example, have a transcript of an interview that your client gave at the border, take a look at that pretty closely. And if there are things that your client is, you know, that this document suggests that your client said that you think are inaccurate or that hurt your case, object to its admission. You know, there you say, I haven't had an opportunity to review this document. I don't know its origins. The person who conducted this interview doesn't appear to be available for cross-examination. If the government wants to make the officer available for cross-examination, I would like, you know, then I'll consider, you know, not objecting if I have the opportunity to cross-examine him or her. But barring that, I object to the admission of this evidence. And there's good case law in the Seventh Circuit about the dubious nature of those credible fear interviews or those border interviews, and the circumstances that they're taken under, and the fact that those aren't verbatim transcripts. So be ready to put up a fight and keep that evidence out, or even if you don't keep it out, get your objection on record so that if it later becomes something that the judge uses to impugn your client's credibility, you've got your objection on record, and maybe that's a point that you can make on appeal. And if you get some, you know, if you get blindsided by some evidence by the government at your hearing, ask for an opportunity to respond. You know, ask the judge for, you know, rather than closing the record, to give you the opportunity to file a written closing statement or a supplemental brief to respond to the evidence that the government has produced, so that again you're pushing back and you're preserving every option for your client and for appeal in the event that that happens. So let's move on to the next slide, which I think is the end. This is my information and Ashley's information. We're always happy to talk about any questions that arise as you're gathering evidence, preparing briefs, and working up your cases. To the extent possible, we like to review outlines of your briefs, and you know, when possible, we can you know, weigh in on your briefs and help you with your writing. Definitely, you know, do your best to give us a little bit of lead time so we know it's coming down the pipe and can prepare for it, and hopefully meaningfully respond and be most useful to you. Ashley, was there anything more that you wanted to share on these points?
Yeah, just to add, you know, like Lisa said, we are very happy, especially at the court stage, to review the briefs of our pro bono attorneys before they're submitted. If you have a case and you're not a pro bono attorney through NIJC, even though we're not going to be able to assist with that level of support, you are welcome to utilize many of the public resources on our website, including our asylum manual, links to country condition resources that could be helpful to corroborate your case, and our practice advisories and these webinars as well that you can review. So even if you're not an attorney through NIJC, you're welcome to utilize those public resources, and we encourage you to do so. And I don't think we have any questions entered through the software, so we will end now. But thank you all again for participating, and this webinar will soon be up on our website as well if you wish to access it at a later date. Thank you.